Good afternoon to those of you on the East Coast, and good morning to those of you on the West Coast. My name is Felix Shipkevich, and thank you for joining us for end of year webinar. I am honored to have a co-host today, Nick Kosmas, who will introduce himself shortly. While today is the last webinar of the year, we've done a number of them coupled with an in-person event in Costa Mesa last month. We're excited that we have a pretty good following of listeners who enjoy our webinars, email us regularly, and download them for use for their compliance purposes. Today's format is going to be a little bit different than previously. Today, I would like to have an open discussion, a dialogue, and we'll discuss a recap and throughout the presentation. But I'd like to have a discussion with Nick, and he'll ask me questions, and I'll ask him questions, and hopefully it will be a fun and productive discussion. So here's what we're going to cover. We'll talk about the legislative update, regulatory update, and the litigation update. And at the very end of the presentation, which hopefully you'll stick around, we'll have the forecast, our own personal opinion and forecast for 2022. Nick, please tell everybody a little bit about yourself.
Thanks, Felix, and thank you for having me today. I'm the general counsel for ClearOne Advantage. I've been with ClearOne going on 3 years now. And prior to that, I was regulatory and managing counsel for the U.S. division of Laureate Education, a for-profit private higher level education university. Where, similar to debt settlement, the debt settlement industry, we engaged in national outreach and sales and I was in charge of both local operations and national regulatory function there. So excited to be in the debt settlement space, and really happy for you to have me here today, and looking forward to this. So thank you.
Excellent. Thanks, Nick. I do want to say that you're one of the very few people in this industry who I believe is extremely knowledgeable about the regulatory and the legal environment. I've known you for a few years, and I'm every time I speak to you, I'm always impressed by your knowledge. So I'm so honored to have you here. Thank you, Nick.
Thank you.
A little bit about myself. I'll keep this slide for about 5 seconds. It's the same slide that you see everywhere. I'm an attorney. Now I'm based in Miami, but I run a firm with New York, Miami, and London offices. I teach at Hofstra Law School, where in a couple of weeks, I'm going to have to start the very difficult trip back and forth every week from Miami to New York to teach. But I enjoy doing it. And I also very involved with CDRI, a new trade industry association in the debt relief space. And I work closely with Nick and Tomas Gordon, who's the president of this organization. And we've done a lot of great things this year. And please find out more at debtreliefadvocate.com. So, Nick, how was your 2021? Tell us what you thought about this year from the legal and regulatory and legislative perspective. I'd like to get your thoughts.
Well, 2021 was definitely an interesting time from a lot of perspectives. We, at ClearOne, and like a lot of our CDRI members and other industry members that I'm in touch with, had to deal with the middle and peak of the pandemic and how that affected our businesses from an employment and regulatory standpoint, whether it was mandates, work from home situations, and all the issues that involved packing up businesses and sending them out into people's homes and still providing the services we need to for our clients. So we worked through those challenges, combined with the change of administration. I believe really, we spent 4 years in what I would describe as a more relaxed federal regulatory atmosphere, but a more heightened state regulatory environment as the states kind of stepped into the vacuum that was kind of left, in the previous administration. And then with the changeover, we're starting to see, I wouldn't say a relaxation on the state side, but a pickup on the federal side. So as everybody's coming back from their pandemic life and back into somewhat more normal business operations, we're seeing regulators kind of wake up and get back to work. So we definitely saw an uptick in that, as we saw nationally with our trade association work, and then on a business level, also a more heightened attention. And then I think also, again, we've seen as business has adapted and now is rebounding fairly strongly. We're starting to again see the same issues that generally come up when it comes to working in this space. So getting back to normal, but definitely a new normal.
Yeah, definitely new normal. That's a good point. I could not agree with you more that we've seen a significant increase in state level activities that we haven't seen, at least I haven't seen for years. I've definitely seen a lot more activity from the state of California than I did before. And what's also interesting is that other states, particularly states that in the Midwest that have been not as active in the debt settlement space, are looking at some of the activities in 2021. I've been looking at some of the activities of front ends. So very different year, wouldn't you say? Kind of not a crazy year, but different.
Yeah, I agree. I think that our industry is obviously becoming more well known and recognized, but also less understood, perhaps, by some of the regulators. So we've spent a lot more time this year, I think, having, I would describe, productive conversations, but as with regulators or with basically anybody who's looking into our space and has questions, whether it's on the civil side or from a government agency. But it's definitely been challenging, but in the end, I think we're moving into a good space.
I agree. I think that you and I both agree that companies that are compliant and take regulation seriously are going to be around for a while. And I think that we're seeing a lot more credibility and legitimacy in this space than we did before, primarily because some states are looking to adopt regulations. We'll talk in a few minutes about California, but it was hectic here. But in comparison to dealing with federal regulators in the past decade, I have to say that 2021 was very state-heavy focused year.
Yeah.
So
I agree. I think what the industry is recognizing, and I've seen it in my practice through the years, is that good compliance can actually be very good for business. When done effectively, it takes a lot of uncertainty out of the market. It allows consumers to feel more comfortable about their decisions because they have a level of comfort knowing that there's watchdogs looking over the industry, and that the good compliant players are actually able to increase market share as a result. And also, as we're looking to the financial markets to support our industry, that certainty definitely helps.
Absolutely. It's also like you and I deal with regulators all the time and also with legislators. And it's always great when you can come into a conversation when they know about your industry and they don't always look at the negative parts. So I've always been a proponent of reasonable regulation being the catalyst for good business growth and, customer protection for consumers. So
absolutely.
I think we've seen that in 2020. I think that's probably one of the more positive things we saw this year. And hopefully 2022. So let's talk about California. I have a few slides, and obviously this is what you'll see in the next few slides for the audience. This is obviously a little tiny piece of what California legislation and the proposed regulation are really discussing. For more information, you could obviously check on our website. We have webinars on the subject matter. CDRI had a fantastic webinar that we had specifically as to the state of California legislation. And so this one is going to affect in just a little more than 2 weeks. Can't believe we're at the end of the year. What do you think? Give us your thoughts. So what do you think are the more interesting parts of 1405 and the upcoming effect date?
Well, having been involved through CDRI with pretty extensively in negotiations around this bill, and then seeing the final result, again, the old saying when it comes to legislation is you don't want to really see how the sausage is made, and this is a perfect example of that. The bottom line is, California, the saying is, as California goes when it comes to regulation, so goes the rest of the country. There's definitely a gravitational pull when it comes to that. So from a high level, I think this, what we're seeing in California, we can also expect to see starting to work its way east and become adopted, maybe in the bigger states first, but then, or states that haven't already regulated our industry. So it's here to stay. And I think it's a good opportunity to understand what the legislative intent of, a pretty detailed and admittedly confusing bill, it results in. I mean, this bill, we've spent a lot of time, at ClearOne, coming up with our process and procedures in coming into compliance with this bill. Through CDRI, we've had several sessions and meetings with the compliance and legal groups of our members to kind of really understand how we can best meet the intent of AB 1405, and we think that there's definitely a roadmap to do it. It's going to be a little different than maybe the way some of us have done business in the past. But in the end, California, like any other state that has a strong desire to protect its consumers in the consumer arena, wants consumers to feel comfortable about the decision to enter into debt settlement. They don't want to stop it. They don't want to materially alter it. They just want the consumer properly, the way they feel is properly educated prior to entering into the agreement, and then also to make sure that while the services are being provided, they're aware of what's going on. So we support that. And again, through help with outside counsel, through regulatory counsel, and then through our in-house compliance, we're taking it seriously, and just looking for the right operational process to meet the compliance requirements.
Yep. And by the way, I apologize to everybody. I noticed a little typo after the word guidelines. I was cleaning this up right before the call, but so please ignore that. Apologies. But absolutely. I think what you nailed it on the head. A lot of regulations start in California, and I don't mean necessarily from a consumer protection point of view, but if you look at generally for financial services regulations, real estate industry or mortgage, a lot of them start with California. It's obviously the most populous state, and they sort of moves eastward. And overall, I don't think this was. I think this was a 2-year battle. I don't want, maybe battle is not the right word, but you understand. Obviously, we've done a lot of lobbying and meetings and calls, and I think overall the result is fairly positive. There are obviously a few wrinkles here that I've been asked to talk about, at least as literally as I'm doing this webinar with you, Nick. I'm getting emails about the 3-day cooling period. So I'm happy to provide my feedback during this webinar about this one. This is the second point. So, and Nick, you and I had chats about this. This was not just with you, but I've had it with many other clients, discussing what this 3-day cooling period means and why was it written the way it is. And for those of you who don't know, you're essentially required to provide consumers with unsigned contracts, wait 3 days, and only after the 3-day quote unquote cooling period. You can only have the consumer sign on the contract. What's kind of weird about this, I've never seen this. Have you ever seen anything like that, Nick, in your experience?
Not in this context, no. And I agree with you. We've talked about this. California and a lot of states do have, and this is a right of rescission when it comes to certain transactions. That's not really what this. Look, Felix, you're the law professor, so I'll defer to you about the rules of statutory interpretation. There's a lot of questions in this law. As far as what was the real intent. Because generally speaking, in our industry, because of the TSR, we're already required to not take any action or charge clients, really for anything for such a extended period of time that this 3-day period kind of already fits into that. So, it's going to take some time to really understand what, probably through DFPI and maybe through some through the courts, or possibly going back to the legislature for some clarification to really understand what they're coming at here. Because even in real estate transactions, purchasing a car in California has a 3-day period, but this is just not that type of a transaction. So it is challenging to come up with the right way to comply with this. I agree.
It's challenging, and from a purely academic / customer protection point of view, it just doesn't make a lot of sense, right? I think the spirit or the breadth of the 3-day rescission period is correct, right? I mean, we see that on the mortgage side, for instance, right? Every single state that I've ever dealt with on the lending or mortgage side has a 3-day right to rescission after the contract is signed. But I've never seen and look, almost 2 decades of practicing law, I can't say I still discover things on a daily basis that are new to me, and amazes how much I continue to learn as an attorney and also as a professor at Hofstra Law. But at the same time, I've never seen anything like this. I've never seen regulation that says, look, we want you to receive this contract and sign, you consumer, sit on it for 3 days, and then decide to sign it. I think that it's actually probably counterproductive, because from a consumer's point of view, you want to give a consumer the right to rescind. If a consumer sits on a contract and doesn't sign it, I think that consumer probably will not be looking at it not only for 3 days, but past that. So kind of the reverse is what I was hoping for. And obviously, I'm happy to discuss a few options that have been sort of workarounds that have been discussed by others in the space, and there's been even some kind of an interesting concept called escrowing, which I've heard about a few days ago from a few people, and I just don't know if it works. I think that, in my opinion, again, and I'm giving you my opinion, this is not legal advice, but in my opinion, I cannot imagine the regulators would go after you if you have a contract signed, but the effective date of that contract is not 3 days later. Well, it's obviously different what the law says, but if the effective date is not for 3 days, that signature in effect is really useless, right? Because the effective date doesn't go on for 3 or 4 days, however many days you want to make it. And I really hope that we as an industry could probably fix this ambiguity, and kind of move on to more important things than the cooling off period. I think really should be the right to rescind type of period. But anyway, I don't know if there's anything else you want to add, Nick.
No, I agree. I think we're going to comply with the law. We're going to work with the regulators to help determine what the intent is here, to make sure that the consumer is getting the best protection, but also the benefit of what they're bargaining for, the services they want, because, that's also important too. And when we've talked with the folks out in California, they understand that. So it is definitely going to be an ongoing conversation.
Yeah, and hopefully a productive one. And I think ultimately the I think the industry is looking to work with regulators and protect consumers and give them the ability to rescind the contract during time frame when they can do so without any penalty and damages. But there are obviously other points that we can discuss. We're already 23 minutes into this, and I try to usually limit it to about 30 to 45 minutes. But obviously, there's quite a lot with 1405, and these are just high-level comments. There's also California's Consumer Financial Protection Law that was proposed. There's a comment period. The comments can be submitted through December 20th. Actually, there's a typo. It's 2021. I apologize. Not 2022. It's 2021. So you have another 5 days to submit your comments. I read those proposed rules. I think overall they're pretty reasonable. I like the fact that the state of California will be asking the industry to use the NMLS, which is really the primary online software application that you use for licensing, for debt settlement, lending licenses, money transmitter licenses, mortgage licenses. I think it's also easier because most compliance staff already know how to use NMLS. I didn't find anything that was terribly concerning. So what do you think, Nick?
Yeah, no, I think it's consistent with what we heard in California, and the fact that we're fully expecting that there's going to be some sort of registration required for debt settlement providers in California. This process is going to take a while, but yeah, I think you're right on that.
Yeah, it's pretty straightforward. Nothing too controversial. Pretty reasonable.
Yeah.
And in fact, we're going to talk about Virginia in a few minutes. In fact, I thought it's a lot more reasonable than the rules that, in fact, go into effect today in Virginia. So, in any case, here's just a little chart. Again, it's not for the purpose of providing legal advice, but it's kind of there to help to see what will be required of debt settlement companies, also those that provide student debt relief services. Clearly, this is student debt relief services that for private student debt. The only thing I think I'll mention is what I thought was kind of strange. Well, I'll move on to the Florida slide, but I thought that was kind of strange. The only thing that the fact that this proposed legislation talks about federal student loans, and those loans cannot be settled by debt settlement companies. So I thought that was a little strange. I don't know if you thought that was strange, Nick, but
definitely. Yeah, having spent a long time dealing with Title IV, that was an interesting addition.
Exactly. Okay. Great state of Florida. So last week we had a webinar on TCPA, and a lot of focus was on the Florida statute. How did the Florida mini TCPA, and it's funny because I didn't really call it mini TCPA, I almost think since it's more extensive and broader than the federal TCPA. How does it affect your company, and what are your thoughts about it?
So anytime something like this comes out, you got to take a look at your operations, and you sometimes you learn some things. You think what's going on in the business, but then you find out, well, there's maybe some situations where we're doing things that differently than maybe compliance or legal knew. And for us, that really wasn't the case, but this gave us an opportunity to kind of dig into our overall TCPA policy, and then see if we had to tighten up anything in relation to doing business in Florida. And so it was a good time to just review a policy that's very important, because it is a real hot topic for litigation, obviously, especially private action litigation. Florida kind of goes to my California theory. Things move east when it comes to tighter regulation, and tends to hit bigger states first, and this kind of proved it again.
Yep, exactly. I was actually kind of surprised that Florida would be the state that would enact this sort of mini TCPA. I would have imagined originally that this would have come from California before it came um, um, from Florida. I mean, I usually if this came from Oregon or Washington or California, I would have expected them. But it's in Florida, which is kind of interesting. And having moved to Florida a few months ago, I've noticed with some of the vendors that use text messaging to communicate with my family, right? That they have to comply with the mini TCPA now as of July, and I've been receiving all these opt-outs and all these text messages asking them if I want to opt out of the conversation just to comply with it. So I thought it was kind of an interesting change that I got a chance to experience myself while living here. What's also kind of interesting, and we'll talk about this later, but this law, when it went into effect in July, July 1st specifically, it brought us an enormous, and I say enormous because it's only been a few months, already a number of class actions filed against not specifically debt settlement companies, but other large and some actually publicly traded companies, in fact, for violating this mini TCPA. In the past few months, my firm has dealt with a number of demands or class action threats involving the violation of Florida TCPA, and clients specifically, they're not located in the state of Florida, don't have any offices in the state of Florida, but service Florida consumers. And I think we've been able to communicate and work out successful resolutions, sometimes voluntary dismissals. Well, really not dismissals because there's really nothing filed yet, but very quick and inexpensive resolutions for some of our clients. But you have to be mindful that this is pretty serious, and I particularly for the front ends in this space, I think that you need to pay very, very close attention to how exactly you're communicating with prospective customers, clients, and the back ends could be vicariously held liable. So you have to be mindful. So that's a pretty big, in my opinion, pretty big deal. I think on the state side.
And I think you'll agree, when something like this happens, first thing you got to do is go in and look at what are you currently doing. And one of the things that probably a lot of people that aren't from Florida don't realize is that your first point there, the 8 a.m. to 8 p.m. calling restrictions, Florida has 2 time zones. And most people, if you're not really familiar with Florida, I miss that. Mm-hmm. So you could be operationally, you think compliant when you may not be. So there's always things that you have to look at when these new rules come in and really take a close look at them.
Absolutely. I think this is one that people in this space I found to be so focused on some of the states that now require licensing, and this year we have obviously 2 major changes, Virginia and California, but they forget that there's also the plaintiffs bar, and they love these laws. I mean, they do CLEs on TCPA, so I think it's important to get your Florida TCPA, if you're front end or back end, always be mindful of the Florida mini TCPA compliance efforts. Believe me, I can tell you they'll save you a lot more money than litigation.
The plaintiffs bar, certain members of our brothers over there and sisters make a living off these small little nuances in these laws.
Yep, exactly. Listen, I think, as I said, I joke around about this, but Nick, you've known me, and I'm a pretty much straight shooter. I said, what you will pay outside counsel or consultant to get you in line with compliance is going to be significantly less than what you're going to pay that same outside counsel litigation cost. I mean, litigation is uber expensive. And until you experience your first, as I say, pop your cherry in litigation, and you don't know how expensive it is. And trust me, I've seen in my own eyes some clients that, oh my God, we're glad we got that in order, because once those letters start coming, if you don't have express written consent in accordance with Florida mini TCPA, you're gonna have a difficult time. So I always say to everybody, don't worry about paying for compliance costs now. That's just peanuts compared to litigation. Um, so, all right, Virginia. So the new rules, right, with the financial regulators are going into effect going into effect today. So, uh, what are your thoughts about HB 1553 and also the rules that are going to effect?
Well, again, we've known about it. We've known it's coming, and then with the licensing statute and the new Virginia law, and the legislators and the regulators tend to telegraph what's coming down the pike. That this was announced, and now it's time to start looking at what you're doing again and figuring out how to come into compliance with these.
Exactly. And look, I think I wouldn't say that from a high level perspective, the law in Virginia and the rules are very easy to comply with. There's obviously quite a lot, particularly in disclosures of owners, and a lot of information that's being asked for is a little bit more intrusive, in my opinion, that I would otherwise be comfortable with. I mean, we work on banking applications, and we don't even get to some of that level of detail that's being asked here, but it is what it is, right? You know, $1,000 per violation, of 1,000 consumers, and you're violating 1,000 times thousands a million, right? Obviously, it's maximum amount, but still, it could obviously be very costly. Again, CDRI has information on Virginia. If you remember, you probably would have received the summary. My firm on debtreliefwatch.com has information about Virginia HB 1553. I think you have a lot of great resources available to you, and I hope you can utilize them. So there's really not much talk about the next slide. Just what we included was just Ohio and Massachusetts have currently pending bills, outstanding bills, meaning that they haven't formally gone through the legislative process yet. Again, we have this information available both through CDRI and my firm, in case you want to keep up on some of these. I don't know if there's anything that you want to say about these. I thought keep it pretty short.
No, just our job is in legal and compliance is just always be aware of this, know what's on the radar, and have the right resources in place through outside counsel, through trade associations, through your own networks, just to I always say that one of my main jobs is to try to look around corners, and that's what this is. We don't know what's going to happen. Some of these things come up every year. Some of them get legs, and some of them don't. But just gives you a good idea of what the trends are. And also you got to remember that the individual state regulators talk to each other. The AGs and and their departments have training sessions together. They meet together and really kind of talk about national trends, and then determine if they want to bring it to their state. So you can't assume that any particular state is ever going to operate in a vacuum.
Absolutely. If you remember to the live event that we had with regulators from Colorado, Washington, and Idaho, I'm sorry. There was a question that I asked those three regulators is, do you talk to each other? And the answer was yes, absolutely, all the time. At conferences, conference calls, they have memos of understanding, and the information is shared quite regularly. So better be informed than not. So.
Yep.
I included something about the true lender rule. I know it's not in most people's radar, and it's really not a big deal for the debt relief space, but I think it's important just because this was a very important rule for many, lenders and banks to provide lending services to consumers. The consumer lending space has just grown exponentially in the past decade. I mean, if we go back to 2010, 2011, just at the creation of Dodd-Frank, after nearly 15,000 small, mid-sized banks and credit unions shut their doors, unfortunately, and I will emphasize the word unfortunately because they weren't a part of the problem. It was nice to have the true lender rule in place to provide consumers with greater options and um, unfortunately, and the reason I put this in this presentation is the true lender rule is slowly being phased out. It's being phased out on the state level, through judicial process, as some of the courts basically say that you can't have lending in specific states without being licensed as a lender or without the bank being licensed in that state. And also, a few months ago, and specifically on June 30th, President Biden signed the resolution that repealed the true lender rule technically on the federal level. And just keep an eye on it, particularly if you are in the lending space or if you're planning to do lending. What are your thoughts, Nick? Is there anything else you want to add to that?
Well, yeah, I would just say again, this goes back to the whole theme, I guess, that understand your business, and while you may think this doesn't affect you directly, this could also affect how you interact with third-party lenders. Whether it's referring clients or working with lenders, or even on the settlement side, who the true lender is has always been a very important part of any financial transaction in this space. And fintech growth touches us, so it really is something that you got to take a look at what you're doing. And like we do all the time, whenever these changes happen, just take a look under the hood, and you'd be surprised where you might see some of this intersect, and then go and get the right advice on how to approach it.
Absolutely. I've been dealing with the true lender rule now for about 2 years, and I can tell you that there are different views on the true lender rule and its application from state to state, but you nailed it. You got to take a look under the hood, and don't assume that just because one company is doing it, then they've done their homework. At the end of the day, if once you get that subpoena, you get the regulatory inquiry, or hey, you might get notice from plaintiffs' attorneys that you're lending without a license. What are you going to do? You're going to turn around? And I'm not saying you, Nick. I'm saying like to people like say, oh, well, these other companies do it. Well, they don't really care, right? They're going to look at you, and you have to do your own homework, and you'll look under the hood. And for those of you who are listening, who are my clients, you probably know exactly how many times I've said to you that you can't just look at someone else. You've got to do your own homework. That's not a defense for any type of regulatory inquiries or private causes of action. So let's see, what do we have left? We have a litigation update. I'll go through it pretty quickly, and Nick, feel free to jump in. I only provided litigation update on the Florida mini TCPA, and primarily that really is the one thing that you need to be mindful of when it comes to private litigate causes of action. What you basically have here is you have a number of action, and basically, since this is being recorded, you can go back to this. But every one of these actions, in fact, deals with text messages, right? And that's what we said a few minutes ago. You have to be mindful of text messages. It's not as much, and I shouldn't discount the importance of ensuring that you have the proper compliance with the Florida mini TCPA on the phone calls. But if you look at every one of these, all those cases involve text messages, and text messages are very easy. When the number of letters that I received, the first letters started coming in August from plaintiffs' lawyers. They just attach text messages. That's it. They just have their clients print them out, and versus telephone call, which it's a little more difficult to prove, but text messages are very easy to prove. And you need to make sure that you have the express written consent if you don't want to get in trouble. So I don't know if there's anything else before we talk about 2022 that I forgot to say about 2021, Nick.
No, I think you covered it. It was a busy year. I'm realizing now, looking back, we did a lot.
I know, right? It was certainly a busy year. So let's. What do you think? What do you think 2022 will look like?
Well, if history is any indicator, we don't know, but it will probably involve more of the same, increased regulation in our industry, increased scrutiny by the plaintiffs bar, but also, I think business is returning to a new normal, so there's going to be more opportunities for us, as an industry. So we're going to want to go take advantage of them, but understand that that it's going to be look at California, look at Virginia, and just say, okay, we're probably not going to roll much of that back. It's probably going to be more of that or other. So you got to just be looking around corners. I also think that as we come out of the pandemic, we're going to start seeing maybe an increase in civil actions, private actions. The courts are clogged up, but eventually that's going to change, and so we just got to be ready for that. But overall, we're looking forward to 2022. We think that as the landscape becomes clearer on the regulatory side, the guardrails are in place. We think the industry is going to it's going to be an exciting time for us.
Yep. I think the industry is in much better shape today than it was a year or 2 years ago. I really do. I think it's a little bit more stable, a little bit less chaos, and I think the bad operators were eradicated through enforcement efforts over the past year or two. So that's the good news. I think 2022, in my opinion, is going to be a pretty stable year for this industry. It's going to be volatile, like you said. I agree with you on the enforcement side. I think with Director Chopper being at the head of the CFPB, and clearly he's had quite extensive experience with the Federal Trade Commission, I think we're going to see enforcement actions that will continue to focus on the lending space. I think there'll be the CFPB in my opinion, again, this is just for the record, this is just an opinion, and it's my opinion. But I think we'll see focus on the lending space, credit repair organizations. I think that the credit repair industry has been under the CFPB, on the CFPB's radar for about 2 years. And I would imagine that we're going to see more enforcement actions coming in that space. On the state side, I think California is going to probably take the lead on being the state that will be very active in enforcement efforts, followed by, and because the next question is, well, a lot of people ask me, what do you think? And I think the next states are actually going to be states that we're probably, again, I reiterate, this is my opinion and it's purely my prediction, but I think we're going to see more activity from Midwestern states. I think we're going to see activity from Minnesota. I've seen Minnesota being a little active. I think Colorado could be more active than usual. I think Idaho and Iowa might be more active than usual. So those states, and why do I come up with that opinion? Because that's where I see the CIDs and inquiries coming from, and I think those Midwestern chunk of states are going to really follow California's lead. So California has a new head that she started recently, and I think that as a commissioner, she is going to focus a lot on customer protection. Not to say that previous commissioners did not, but I think we're going to see a much different DFPI than we did before. And it certainly is flexing its muscles on the jurisdictional front and is asking for information that I haven't seen with CIDs or subpoenas or inquiries with previously Department of Business Oversight. It's just a lot more aggressive these days. So if you're a California business, so you have California consumers, consider you've been warned 2022 is going to be a year that you need to pay very close attention to the state of California. And I agree 1,000% with what Nick said, the plaintiffs bar. I've seen more activity in 2021 than 2020 on the plaintiffs bar. A lot more. And I think we're going to continue to see that trend in 2022. Well, that was it for 2022. Anything else that we missed, Nick, in this discussion?
No, this was great. Thank you for having me on.
Yeah, no, absolutely. This is just again, thank you, everyone. Thank you. It's the end of the year. Thank you for being a loyal listener. And Nick, very grateful to you. You're an amazing guy. I've known you for a few years, and thank you for your time. I know you're super busy, and thank you for providing your feedback and your knowledge to the industry. And I look forward to a better 2022 with you, man.
Yep. Same here. Thank you.
Thanks, everyone.